Good day, everyone. I am from Team Cambridge, and I will continue the report on International Covenant on Civil and Political Rights. So, our group will cover Articles 28 to Article 53 of the International Covenant on Civil and Political Rights. Our report will focus on 3 points. We have the mechanisms for reporting and monitoring compliance by the state parties. Second is the manner of interpreting International Covenant on Civil and Political Rights. And the third one is the rules on ratification, entry into force, and the amendment of the ICCPR. The previous group have already discussed the substantive rights that are protected under the International Covenant on Civil and Political Rights. Now, state parties have the obligation to protect these rights. Now, this begs the question on how can state parties ensure compliance with their obligation under the ICCPR. So, we have three words for that. We have it is ensured through effective, accessible mechanisms. So these mechanisms are provided in the following articles that we are going to tackle. So let us start with Article 28 of the ICCPR. Article 28 is the provision for the creation of the Human Rights Committee. The Human Rights Committee is a treaty-based body which is composed of 18 members who are nationals of the state parties. So they are elected and shall serve in their personal capacity and not as a representative of their country. So as you can see in your screen right now, these members are the current members of the Human Rights Committee. Under Article 29 of the ICCPR, the members of the committee shall be elected by secret ballot, and each state party to the present covenant may nominate not more than 2 persons. So as you can see in your screen, we have an actual illustration of nominees. So these people were nominated last April 6, 2022. Under Article 30, 4 months before date of each election, the Secretary General of the United Nations shall address a written invitation to the state parties to submit their nominations. Persons elected will be those who obtained the largest number of votes and an absolute majority of the votes of the representatives of the state parties present and voting. So you can see we have here the current candidates that were elected last June 17, 2022 at the 39th meeting of the state parties to the International Covenant on Civil and Political Rights. Under Article 31, 2 nominees from the same state is allowed, but only 1 member may be elected per state because consideration shall be given to equitable geographical distribution of membership and to the representation of different forms of civilization and of the principal legal system. So we have here the actual illustration on the Human Rights Committee's composition for the period 2023 to 2026. So the gender representation, we have 7 women and 11 men. For the geographical representation, we have Africa, Asia Pacific, Eastern Europe. Article 32 talks about the terms of office of the members of the Human Rights Committee. So the members of the committee shall be elected for a term of 4 years. They shall be eligible for re-election if renominated. So the terms of the 9 members elected at the first election shall expire at the end of 2 years. So this is only applicable to those members who were elected during the very first election of the members of the committee. So immediately after the first election, the names of the 9 members shall be chosen by lot by the chairman of the committee referred to in Article 30. So last June 17, 2022, there was an election held for the replacement of the 9 members of the Human Rights Committee, whose terms will expire on December 31, 2022. Article 33 to 34 talks about the vacancy in the seat of a member of the Human Rights Committee. So there are 3 instances where the seat of that member may be declared vacant. Number 1, if he has ceased to carry out his functions. Number 2, in case of death. and number 3, in case of resignation. So when a vacancy is declared, if that member to be replaced doesn't have a term which does not expire within 6 months, for example, the member who resigned has a remaining term of 7 months. So if that is the case, the Secretary General of the UN shall notify each of the state parties which may within 2 months submit nominations to fill the vacancy. So the Secretary General shall prepare a list of the persons nominated. Article 35 states that the members of the committee shall receive emoluments from United Nations resources on such terms and conditions as may be provided or decided by the General Assembly. And under Article 36, the Secretary General of the United Nations shall provide the necessary staff and facilities for the effective performance of the functions of the committee, such as the staffs for organizing or receiving reports from individuals or from state parties. Article 37 talks about the sessions or the meetings that will be held by the Human Rights Committee. So under Article 37, the Secretary General of the UN shall convene initial meeting of the committee at the headquarters of UN. So the committee shall normally meet at the headquarters of UN or at the UN office of Geneva. Under the rules of procedure of the Human Rights Committee, the committee shall normally hold 2 regular sessions. But there are times when they held a special session to address human rights violations and emergencies. So for the year 2020, they held 3 sessions. The Human Rights Committee will have its own set of officers, so the committee shall elect its officers for a term of 2 years. So their officer will compose the chair, the vice chair, and the rapporteur. So we have here an actual illustration on the elected officers on March 1, 2021. Now we are going to talk about Article 40, the first meat of our discussion for today. Under Article 40, the state parties undertakes to submit reports on the measures that they have adopted, which gives effect to the rights recognized under the ICCPR. So the state party will submit a report to the Secretary General of the United Nations. In the report, they will indicate the factors and difficulties, if any, affecting the implementation of the present covenant. Upon the receipt of the report, the UN Secretary General will transmit report to the committee, and it may transmit report to the specialized agencies. It may transmit of the copies of the parts of the reports which may be under the or within the field of competence of that specialized agencies. And after it was submitted to the UN Human Rights Committee, the committee shall study the report, and it may give general comments as it may consider appropriate. The committee may also transmit a copy of the report that they have considered to the Economic and Social Council for further discussions and debate. Now, let's talk about Article 41 of the ICCPR. The mechanisms for reporting and monitoring compliance by state parties is enshrined in Article 41, the second meat of our discussion for today. So how does it go? First, a state party claims that another state party is not fulfilling its obligation. But take note that before a state party submits a communication, it must make a declaration recognizing the competence of the Human Rights Committee. So, a state party may, by written communication, inform the state party concerned of the non-compliance with its obligation. So we have an illustration here. For example, Kim Jong-un of North Korea and Vladimir Putin of Russia. So for example, North Korea will transmit a written communication to Russia na, "Oy, Russia, you are not fulfilling your obligation under the International Covenant on Civil and Political Rights. Now, within 3 months after receipt of that written communication, the receiving state shall afford explanation or statement clarifying the matter. Now, for example, Russia will respond na, "Oy, North Korea, you are wrong because we are in a state of national emergency. There is a threat to the life of our nation." So, after 6 months from receipt of the initial communication, if both state parties are not satisfied, either parties may refer the matter to the committee. The committee will ascertain the exhaustion of domestic remedies and thereafter hold closed meetings and propose friendly solution on the basis of respect for human rights. So after the submission, the committee will hold a closed meeting and propose suggestions that are amenable to both state parties. Now, within 12 months from after the receipt of that notice, the committee shall submit a report. So, if a solution is not reached, the committee shall confine its report to a brief statement attaching the record of oral and written submission. Now, if a solution is reached, the committee shall confine its report to a brief statement of the facts and the solution reached. In continuation, we have Article 42. So, under Article 42, if the matter referred to the committee is not resolved, the latter may appoint an ad hoc conciliation commission. So, all the information collated by the committee regarding the communication submitted by the state party shall be made available to the ad hoc commission. Now, when the ad hoc commission is unable to complete its consideration, it shall confine its report to a brief statement of the consideration of the matter. Now, when the ad hoc commission fully considers the matter, it shall submit a report for communication to the state parties concerned. So, if there is an amicable solution on the basis of respect for human rights is reached, the commission shall confine its report to a brief statement of the facts and the solution reached. If, for example, a solution is not reached, the commission's report shall embody the findings on all questions of facts and its views on the probabilities of amicable solution. Now, the report shall contain records of oral and written submission by the state parties. So, the job of this ad hoc conciliation commission is to reconcile the opposing approach of each state party. So, if a solution is not reached, now the conciliation commission will include its views on the probabilities of amicable solution. Now, within 3 months from the receipt of that report, because that report of conciliation commission will be transmitted to the state party. Now, the state party shall notify the chairman of the Human Rights Committee whether or not they accept the contents of report of the commission. Whether or not the state party accepts the comment of the ad hoc conciliation commission, the communication will not stop there. So it will only stop if a resolution or a solution is reached which are amenable to both parties and in accordance with the rights protected under the ICCPR. Let us now go to Article 43 to Article 44. So Article 43 provides for the entitlement of the ad hoc commission members for the facilities, privileges, and immunities of expert missions for the United Nations. Article 44 covers the application of the ICCPR. So the provisions for the implementation of the present covenant shall apply without prejudice to the procedures prescribed in the field of human rights by or under the constituent instruments and the conventions of the United Nations and of the specialized agencies, and shall not prevent the states from having recourse to other procedures for settling a dispute in accordance with the general or special international agreements in force between them. So if they did not reach a amicable solution under the Human Rights Committee, then they can seek a recourse to other procedures for settling disputes in accordance with other special international agreements that they are a party of. Article 45 states that the committee shall submit to the General Assembly of the United Nations through the Economic and Social Council an annual report on its activities. So on your screen is a cover for the Human Rights Committee's report on its 129th, 130th, and 131st session. And under Article 46 and 47, Article 46 and 47 underscores that the International Covenant on Civil and Political Rights shall not be interpreted in any manner that will impair the implementation of the United Nations Charter and specialized agencies. Now, the ICCPR shall also be interpreted in a manner that will not impair everyone's inherent right to freely and fully enjoy their natural wealth and resources. Now we are in Part 6 of the ICCPR, the rules on ratification, entry into force, and amendment of the ICCPR. Part 6 covers Article 48 to Article 53. So, under Article 48, the ICCPR is open for signature by any state member of the United Nations or member of any of its specialized agencies. It is open for signature by any party to the Statute of International Courts of Justice and by any other state which has been invited by the General Assembly of the United Nations to become a party to the present covenant. The ICCPR is subject to ratification. Instruments of ratification shall be deposited with the Secretary General of the UN. And accessions shall be effected by the deposit of an instrument of accession with the Secretary General of the United Nations. The ICCPR shall be open for accessions by any state mentioned in paragraph 1, such as the member of any of its specialized agencies or the state party of the Statute of International Courts of Justice. Now, the Secretary General of the United Nations shall inform all states which have signed this covenant or acceded to it of the deposit of each instrument of ratification or accession. Under Article 49, the ICCPR shall enter into force 3 months after the date of the deposit with the Secretary General of the UN of the 35th instrument of the ratification or the instrument of accession. For each state ratifying the ICCPR or acceding to it after the deposit of the 35th instrument of ratification or instrument of accession, the ICCPR shall enter into force 3 months after the date of the deposit of its own instrument of ratification or instrument of accession. For Article 50, it states that the provisions of the present covenant shall extend to all parts of federal states without any limitation or exceptions. In such a case, under Article 50, the federal authorities who usually represent a state party before the committee must take such measures as may be necessary to ensure that the covenant or the ICCPR is fully applicable within its territory and that the necessary remedies for violations is available. In this sense, Article 50 is a restatement of the well-known principles of international law whereby a state's international responsibility is engaged by the acts and omissions of its authorities at all levels, whether national, provincial, or local, and that a state's domestic law does not excuse a breach of a treaty obligation. Article 51 of the ICCPR talks about the amendment or the proposal of amendment to the ICCPR. So, any state party to the ICCPR may propose an amendment and file it with the Secretary General of the United Nations. It will be thereupon the Secretary General of the UN shall thereupon communicate any proposed amendments to the state parties to the ICCPR with a request that they notify him of whether they favor a conference of state parties for the purpose of considering and voting upon the proposed amendments. Amendments shall come into force when they have been approved by the General Assembly of the UN and accepted by 2/3 majority of the state parties to the present covenant in accordance with their respective constitutional processes. So when the amendments come into force, they shall be binding on those state parties which have accepted them. Other state parties is still being bound by the provisions of the ICCPR and any earlier amendment which they have accepted. Under Article 52, irrespective of the notifications made under Article 48, Paragraph 5, or the notification on the deposit of accession or the deposit of the instrument of ratification, the Secretary General of the United Nations shall inform all states referred to in paragraph 1 of Article 48, such as those state parties of specialized agencies or state parties to the International Courts of Justice. So they will be informed by the Secretary General of the signatures, ratifications, and accessions under Article 48, and also the date of the entry into force of the present covenant under Article 49, including the date of entry into force of any amendments under Article 51. Article 53 talks on the dissemination of the copies of the International Covenant on Civil and Political Rights. So the ICCPR, of which Chinese, English, French, Russian, and Spanish texts, which are equally authentic, shall be deposited in the archives of the United Nations. Now, the Secretary General of the UN shall transmit the certified copies of the ICCPR to all states referred to in Article 48, such as those specialized members of UN specialized agencies or those state parties of the International Courts of Justice. The ICCPR have actually two optional protocols. So the first optional protocol enables the Human Rights Committee to receive and consider communications from alleged victims of the violations pertaining to civil and political rights. The second optional protocol delves on the promotion of the universal abolition of death penalty. Now we have here the individual complaint process in relation to the optional protocols under International Covenant on Civil and Political Rights. So how may an individual submit a report regarding the violation of his civil and political right before the Human Rights Commission? So we have here first the submission. The individual may submit a report on the alleged violation of his civil and political rights to the UN Secretary General. Second is the enlistment. The complaint of the individual will be registered or formally listed as a case for consideration by the Human Rights Committee. But before it can be considered by the Human Rights Committee, it must first be forwarded to the state party for its comment. And after the submission of the comment by the state party, it shall be forwarded to the complainant for its comment on the comment of the state party. Fifth, the examination of admissibility. Now, before it can be examined or by the Human Rights Committee, the committee will consider whether the case of the person fulfills the formal requisite of admissibility. So what are these formal requisites of admissibility? Number one, if whether the domestic remedy has been exhausted, so whether the individual has fully exhausted all the available domestic remedies in his home country. Second is whether the complainant has been personally or directly affected by the alleged violations, while other person may bring a report or a communication as a representative for as long as he have the consent of that person directly affected. And lastly, whether the complaint is sufficiently substantiated, whether it has enough evidence to be considered by the Human Rights Committee. Now, number 6, if it meets with the formal requisites, the committee will now proceed to the consideration of the merits of the case. This is to establish whether the state have really violated or may violate the complainant's right under the treaty. So next is the Human Rights Committee may, in urgent situation, request the state party to grant an interim measures to prevent irreparable harm. Such requests are normally issued to prevent actions that cannot be undone. For example, the complainant is on a death row or is charged with the penalty of a death penalty. So the Human Rights Committee may request for the suspension of the execution of the death penalty as an interim measures. And now, if a violation is found, the state is requested to provide an effective remedy and respond to the committee within a set deadline. So we have already the second optional protocol of the ICCPR promotes the abolition of the death penalty. So the Human Rights Committee may request to provide other alternative remedies such as life imprisonment instead. After that, it shall be transmitted to the state party, and the committee will submit a request for information on implementation of the decision. So the committee will request on how was the implementation of their suggestion of remedy was going, how was it going. And after that, the submissions received from the state will be forwarded to the complainant. So for example, if the death penalty was abolished by that state party, the complainant will be informed that you are hereby sentenced to life imprisonment instead of death penalty. So that's all. Thank you and have a good day. Oops.